I don't know how many of you are involved in the actual drafting of privacy statements. I am more often than I'd like to, but that's the nature of having wide global business lines. And it even pains me to say that even in an organization as wide as mine, which has data protection officers and privacy officers in almost every single region and country imaginable, these are the exact conversations that we have even internally, because put 3 privacy professionals in a room and you'll get 5 outcomes to any given situation. This being just one more example of where exactly does your appetite lie when you're trying to explain really easy, simple business processes. Your organization will probably be emailing people to just have a conversation with them, be it service-oriented, be it support-oriented, whatever. Say that, to Heike's point, you have completely figured out your data mapping, you figured out how long you're actually going to be retaining records of email conversations for service improvement, for maybe even statutory retention periods, if that's your drive. How will you make this transparent to people? And I think by and large, there are probably 2 ways to go, right? And we'll see this across the entire PowerPoint presentation. There are very legalistic ways to draft anything that you like to draft. I will be using your contact information for communication purposes, albeit solely for administrative functions, et cetera, et cetera. Even for those of you who have a legal background, this is language which is hard to digest. Like, it's going to take you a minute to figure out, oh, they're talking to me about sending me an email. Great, wonderful. I don't exactly mind them doing so, and now I understand what it's going to be used for. On the other hand, there is probably a different way to interpret easy to understand in a very, very audience-friendly manner. By way of the example here, we're going to be talking about sending you emails. What does your organization usually do in terms of communications, and what is your target audience? How do you talk to your target audience usually? But actually, I'll turn the expert shoe over to you guys first. So, I think many organizations receive DSARs once in a while. I don't think we've seen the avalanches that were predicted back in the day, unless you're one of those companies, in which good luck. Audience question. What we've put up on the screen are 2 possible ways to respond to simple data subject rights requests. With a show of hands, who, you can speak for your own personal preference or for your organization, not really relevant, who would say that they respond to DSARs with the first example, the overly legalistic response type?
Oh.
There's no shame, you can raise your hand. Who would say that whenever they get a DSAR, and if you're in charge, right, maybe you've actually outsourced this internally, who would say that they respond in a more simple manner, like the second example that we have?
Somewhere between.
And I can see a lot of people not raising their hands, so they may... I don't know if there's Chatham House rules, but this is a safe space.
I think we've learned that 50% is legalistic, 50% is simplistic, or 25% is simplistic, and then 25% maybe doesn't respond to the DSAR?
If so, there's no regulator in the room, maybe. Who knows? But I think this is probably what privacy programs can do, right? I think DSARs, because they haven't been as prevalent as maybe some people predicted back in 2016, 2018, means that we imagine that a lot of organizations still sit in a legalistic vibe when responding to these, probably for good reasons, right? Because as Heike mentioned, whenever you do get a DSAR, in some cases it may be somebody, harking back to previous examples, just asking for the driver's license because they need it and they know that the bank has one, they just need it ASAP. Could be a person doing a digging operation, although it is, of course, difficult to assume these things beforehand. We definitely don't advise that you do so. More mature privacy programs may have already taken a more left field approach, having spoken with their internal comms organizations, trying to figure out what is our brand as an organization. How do we usually interact with our consumers, whether they're children, whether they're adults? What kind of industry do you sit in if you're in financial services? Maybe you already have a way of communicating that is always going to be a little bit more heavy, right? You don't want to be speaking to adults as if they're just your neighbor down the street. So here we will not suggest pick either example, but do speak with your internal colleagues once in a while. Right? Privacy offices do not exist in a vacuum, especially if you may have outsourced responding to DSARs to internal organizations. Try to find language which marries your own risk appetite, your profile within the industry that you work with, and whatever type of normal communication that you would have, because in the end, the people who ask questions of your organizations is going to be normal people, with the exception possibly of activists, but hey, they're people too. So what could you do? If you aren't sure what your organization could do, or if you're wanting to test some things out, why not stick to more of a middle ground position? Because all fun and jokes aside, in the end, responding to individual rights requests still is a matter of legal obligations. We can try to make our privacy programs a little bit more fun, a little bit more easy to understand, accessible, and the whole lot. But you can never quite be sure what's going to be around the corner. There can be one person pretending to be nice and asking questions. You may even just have a regulator knocking on the door at some point in time later, asking to review your definitely way up-to-date data subject rights request log with accurately retained logs of what you have responded at what time and evidence of any documents that you may have provided in an easily accessible format, etc. So good luck. What can we do then from like a more operational privacy program perspective to try still instill these intelligibility requirements into our correspondence with data subjects, right? Because we know that Article 12 doesn't just apply to privacy statements, be it in Article 13 or 14 situations. They need to be instilled in any kind of communication with individuals. Try to step away. This is what I'm trying to do with my organization. I won't say it's easy. Try to step away from the more tick-the-box approach. If you have predefined formats that you've told people to respond, like take them back once in a while, try and see if you can make them more human-sounding, because maybe there are templates that your outside counsel drafted 6, 7, 8 years ago. Maybe legal counsels had a look. See if you can take it back a little step. If you do have a person who is pretty aggressive, I would say there's no harm in being a little bit more legalistic. You are still there to also defend the interests of your organization. What we've also seen in the benchmark exercise, which Laura alluded to, maybe your organization has information on its website that is something that is accessible to people directly that you can refer to in your DSAR responses. If people ask general questions, there's absolutely no harm in responding to their question, providing more context other than your legally devised template 6 years ago, but to also refer them back to a privacy statement, to a preference center that you may have. These are ways that we are still trying to find a fine balance between responding to actual questions in an easily understandable manner, but also making use of resources that our organization has worked on to be more transparent and easily accessible to individuals. So where you can, why not try to make a couple of things work together?